Hello and welcome, everybody. This is the TIPS Dispute Resolution Committee Meet the Authors program. This concerns the summer 2024 issue. We have 3 of the authors here. This is a regular program that we offer to allow the authors to expand upon what they wrote about, to answer questions that you might have, and so that you can learn something about their backgrounds, which I think are all very useful to us. So again, welcome to everybody. I'm going to ask each of the authors some questions to prompt some good discussion. If people have questions, there'll be time at the end. Usually these interviews will run about 15 minutes, and I'll open it up to anybody else who might have any questions. So there should be plenty of time for that also. So I'll start with Lisa Savitt. She's with Benchmark International ADR. We also have Rick Alimonti with Alimonti Mediation Services PC here, and Steve Schulwolf with Schulwolf Mediation PLLC. And we'll start with Lisa, who provided her article entitled Practical Considerations for Mediations with International Parties in the summer issue. Lisa, welcome.
Thank you.
Can you tell us how you became interested in alternative dispute resolution?
Well, as some people may know already, I started my career in aviation on the sort of personal injury, product liability defense side, hence the long standing membership in TIPS. But mediation is just part of our lives in that field. And I became very interested in having clients do mediation where appropriate, and started to understand the complexity of being a mediator, and it just was a challenge. So I decided to start pursuing that.
What was your entree into international ADR in mediation?
It's really my whole career has been international.
Yeah.
I started my career in aviation, which is in itself international. I had international clients, had cross-border litigation, and so started early on with that interest. And with international mediation, it's just a whole, it's complex enough to be a mediator, but when you have parties that are from other countries, and they don't even have to be, they could be living in the United States and be from another country, or they could be from abroad. You have commercial disputes or product liability disputes where manufacturers from another country, and there's just a whole host of considerations that you have to take into account on top of the layers that you have anyway, being able to read people and to understand the dynamics. So early on, I had a mediation involving a French client, and the plaintiffs were from Lebanon. And when I was looking for a mediator, I wanted someone who would understand cultural differences of legal systems, which I know we're going to get into a little bit about damages, but trying to understand that and realize it's really a specialty. There aren't that many mediators who've done mediations with international parties or international other legal systems.
Right. Yeah. In the French system, there's virtually no discovery, right? It's what there is conducted by the magistrate or the judge.
In the civil law system, there's no such thing as discovery. So it's not just France, it's many other countries. And there are other countries who have other legal systems that do not have discovery, or they have not how we understand it. Even in England, it's much more constrained, although some of them are trying to follow the US pattern. But yes, it's very different.
Right. And so if we in the US, we of course are trained to appropriately emphasize the potential costs and time involved in litigation. In a jurisdiction where litigation isn't as costly or time consuming, is it more challenging to get parties to realize the value of resolving the case privately?
There are a lot of countries where people don't have experience with mediation at all. So that the whole concept is a bit foreign. It can still take a long time in another country. I mean, I think what Rick would probably know is in Italy, it can take 15 years to get your case to trial, but that's not because it's ongoing and there's costs going on. It's just the court system is overloaded. but certainly, with my clients, a lot of them just had no idea what a mediation involves and would confuse it with arbitration, which can be very costly these days. So it's just a question of educating them. Or if they know mediation, they know it in the context of family law or landlord-tenant law in their country. So they don't have the concept of mediation to resolve more complex disputes, including product liability, personal injury, commercial disputes.
Interesting. When I made my first business trip to Germany, some of our colleagues over there cautioned me regarding meetings, don't be late, and also don't be early, which I found kind of challenging. How do you learn when you're conducting a mediation with people from outside the United States? How do you discover what customs and norms might be important for you to know in preparing for the mediation?
Well, first is to ask the lawyers if there are any particular things that you should know in terms of cultural differences or even religious differences. The case I referenced way back when, involving the Lebanese family, my first question was to the mediator to ask the lawyer, is the family Christian or Muslim? Because in Lebanon, they have two legal systems. And it would be different, and also culturally would be different. Normally parties walk into a room when we had more in-person meetings and would shake hands. But if the people of opposite sex don't shake hands in that country or under that culture, then you don't want to walk in and make a faux pas that will set it off on the wrong foot. So in terms of being early or late, that's another thing to learn. There's books out there. There's Kiss, Bow, Shake Hands. Terry Morris, I think her name is. I wrote it in my article, but she writes a whole series of Kiss, Bow, Shake Hands covering different regions. So for example, if you go to a meeting or a mediation or involving people from Latin America, and it's a stereotype, but there's a lot of truth in it. It's traditional to show up late. It's just, that's, not abnormal to be 20 minutes, half an hour late. So you have to think how you're going to handle that if the other party is used to prompt, starting. Again, you have to reach out to the lawyer and let them know that, no, this mediation is going to begin on time, and you'll be doing your client a service if you don't make sure they're there. So I think it's being aware of cultural differences from sources like Kiss, Bow, Shake Hands. The State Department has on their website a little bit about cultural differences. There's a lot of resources out there, but at the end of the day, would ask the lawyers involved, is there anything particular you should know about who they're representing in terms of their culture or expectations, which you do anyway. You just add that dimension.
Good. Your article speaks about damages in many countries being considerably lower than what's awarded on average in the United States, particularly in personal injury cases. Can you talk a little bit about what you've learned about that and how that has impacted mediations involving folks from overseas?
First of all, most countries don't have punitive damage as a potential, so that in a case where it's been claimed, they won't have that understanding, and you have to come with that mind frame that the one party may not understand what even punitive damages are. In terms of the actual damages, so it's not just that damages are lower, but there's often a formula. Like in France, there's a formula. If the person breaks an arm or loses an arm, there's a formula for how much money that person will get. If it's a death case, there's a formula based on their earnings over time. So it's really a question of educating them when they come to a mediation, that the litigation space in the US, that first of all, it's possible that foreign law will apply. That's always very difficult in our court system. Judges aren't familiar, and obviously you have to have expert testimony and all that. But you need to educate them, or have their lawyers educate them about expectations of damages and what the real risk is. And it's not easy when they're not familiar with it at all. And when they do hear verdicts or damages the United States. They hear of the McDonald's, over the top verdicts. So the lawyers your role is not to educate them, but the lawyers need to educate their clients with whatever verdict reports or their own experience.
Yeah, we're in personal injury cases where the amounts at stake are large. Seems that structured settlements are increasingly popular in the U.S. Do you see those in overseas mediations?
Again, no, I don't. But it's something that a tool in the toolbox that a mediator should be prepared to use and explain what they are and the benefits. It's all about education and teaching, the benefits of mediation in terms of, especially in terms of the longer trajectory. So if it's a product liability case, protecting the product, resolving the case so that they go on and do their work. Also in commercial disputes, often will be between parties that maybe want to have an ongoing relationship. So always, I think mediation is a wonderful tool, not only because of cost saving, but because of the innovative ways that you can come up with settlements that allow people to go about their lives.
Right, good. Your article also talks about people from outside the United States sometimes seeing mediation as something different, maybe something more like arbitration, and having the impression that you as mediator might have some authority to actually resolve the dispute. How do you address that while still, keeping your authority as somebody who's going to help resolve the dispute clear?
I think it's the same as when you have parties who are not from overseas, right? It's explaining it, and also whether you're going to be evaluative or facultative, and letting them know what your role really is. I think recently had a matter where the parties had a court-ordered mediation with a magistrate, and it wasn't a good experience, and they had to be talked into a private mediation. And I, there was a lot more flexibility with a private mediator in terms of it not being like 3 hours of time of the court. Private mediators will stay with it until the parties resolve it, even if it takes weeks. But, I think that it's not so different in terms of educating the parties about your role. And even during the mediation, and the other speakers can attest to this, during mediation, parties often forget that what you told them, that you're not the judge, that you're not making a decision, and you have to bring them back to reality, that they're there to resolve their disputes.
I've experienced more than once, not just parties, but lawyers who really don't seem to understand the confidentiality of mediation and will file a pleading in court, going pretty thoroughly over what was offered and demanded in a confidential mediation. Is that more or less of an issue in overseas mediations?
Again, when you say overseas mediation,
yeah, sorry.
Where is the case based? Because that will make a difference. If the case is based in the United States, it's the same issue, right? Whether that's breaches, what that breach is, and what a judge will do about it. Overseas, in another legal system, confidentiality is pretty, privacy is a big issue in Europe particularly, and also in Asia. So it's pretty important, and I don't think that I know of any violations. But the other thing is, in many countries, mediation is still very new. I'm living right now in Austria, and it's just not a known animal, except again for maybe family law. The courts aren't pushing it, businesses aren't using it. So it's a question of education. Why
do you think that, just to follow up on that, why do you think that, at least in some countries in Europe, the courts are less inclined to require the parties to engage in mediation?
I just think it's a different legal system and a legal environment to some extent. I mean, this cases, you don't have the discovery, the judge retains a lot of control. The judge usually appoints the experts, and parties don't appoint the experts. I think there's a more of a push to use it more, and it is being used more in other countries, in Switzerland and certainly in France. And you see a lot more practice that used to be international arbitration, now it's international dispute resolution, because they are doing more mediation, particularly private. But it also comes from the courts pushing, and the courts just don't have that that practice of doing it.
Right. Yeah, that to me, that would take away one thing I always like to say to parties who say that they want to litigate, which is you might want to, but the judge might tell you to go back to mediation. So that would be, yeah.
Yeah, the other interesting thing, I was at a conference recently which talked about people that start with an arbitration, and then the arbitrators refer them to mediation, sometimes with the same arbitrator. I think it happens in the US.
Does.
And that doesn't work, you go back to the arbitration. So the lines are being blurred, and there's all kinds of ethical issues involved. It's interesting. We're going to hear about some other new exciting things with Steve, but
Yeah. Yeah, there's still a controversy about whether somebody mediating the case should act as an arbitrator later. I think the parties have to know that before they mediate, that could happen. Otherwise, there may be some things that they would not want to say to the mediator if the mediator is going to be adjudicative. How does the use of interpreters within a mediation affect the mediation, if at all?
It makes it longer. It definitely makes the mediations longer. I think it's really important to have interpreters when, for example, if it's a case in the United States and the person's party's first language is not English, even if they use it in business, it's still better, particularly when it comes to legal terminology or technical terminology. It's better to have an interpreter, so you make sure the parties are hearing it and this, understanding it. I've been in mediations, not as a mediator, but years ago, where the lawyers knew just enough French to be dangerous and would start correcting the interpreter. And there's always that danger the interpreter doesn't get it right. But interpreters, by and large, are pretty well trained. And I think it's just really vital if English is not their main language. Also for depositions, I mean, going away from mediations, I think it's important to have an interpreter if if your client speaks another language, and they can get in a lot of trouble because if they don't use it every day fluently, it can be a lot of misunderstanding. And one thing you want in mediation is you want the parties to understand what you're saying, what you're trying to do.
Right. Yeah, I had a case involving a French client where the word at issue was the word guarantee, which is very similar in France, except that it means something different. And
Legal concepts could be different, right? So as well.
Right. The interpreters, would they sign the mediation agreement along with the parties? At least for purposes of confidentiality?
It's a good question. I think there should be some designation that the matter was interpreted, whether it's in the mediation agreement or another side agreement in terms of confidentiality. I think it'd be done either way.
Good. Okay. The last question I have is, particularly where we're dealing with damages that may be capped, fixed by statute or regulation and so forth. And so a runaway verdict isn't really much of an impetus to resolve things. How do you address parties' concerns over what the cost of a mediation is going to be in terms of your fee, their lawyers' fees, and the time involved?
First of all, I think there has to be trust. Trust in the mediator. So the party should have done a good job in involving the client to choose the mediator. so they know you're there to help them resolve things. Obviously mediations can get pricey, but with proper preparation about what's involved, the parties should be aware that it's not going to be as pricey as litigation or arbitration. So I think it's education and trust. But you can never, parties are always going to be unhappy about costs, I think. So you have to give them value for their money. And if they feel that their side, each side has been heard, and that you've addressed their concerns, and that you've allowed them to negotiate, I think that the cost would be less of an issue, whether it's international or not.
Well, thank you. Is there anything else that you wanted to talk or add to what you've told us already?
No, I do think it's just about being able to read the room and to be able to understand where people are coming from, so that you can be an effective mediator, and it involves any kind of international component. You should be educating yourself, and then educating, making sure the other parties understand the differences as well. So I think the culture of mediation is really important, in terms of not just our legal system, which is overloaded, but other legal systems as well. So I think that we all need to do a good job so that we can make more people realize how valuable mediation is.
Right, that's very good points. Thank you. Steve and Rick, since this is my first one of these, in terms of opening it up to questions, would you recommend that I ask people to use the chat function to convey it, or do we have the capability to bring them up so that they can ask a spoken question?
I think at this point, it's however you or Gene want to do it. I know in the past we've had chat or the Q&A function, and I'll defer to you as moderator in terms of when it's appropriate if you get some question from the gallery as to when to pose it.
Yeah, I think technically it will be easier to use the chat function, so I'll ask any of the viewers who are on to use that, and then we can return to Lisa later in the program. Okay, next up is Steve Schulwolf. He is a longtime mediator and the author in the summer 2024 newsletter of AI and mediation, not quite ready to take the inevitable plunge. Steve, when did you become interested in ADR as part of your practice?
I would say both on the front and back end of my practice. I started out in big law, and I think Rich, like you, and at some point, Rich, I'd like for you to introduce yourself so that Rich has taken over from me the gauntlet of being the editor of our newsletter. You're doing a great job, and we appreciate that. But I started out in big law, and I remember, like you, I was doing some insurance coverage cases. And this goes back into the early 90s when firms that were representing the London market in large environmental mass tort claims actually reported to the market quarterly and then drew down on escrows without any audit. And as part of those reports, there usually were some types of settlement valuation. And I remember learning different nuances of a large coverage case, trigger allocation, and I had partners who were explaining everything to me. And I had no idea what I was doing. I was like a fourth week in my practice. And so I didn't really understand completely all the legal issues, but I had the audacity to say, I don't think you're doing the probability correctly on this. And everybody was like, and so we kind of walked through, and because I opened my big mouth early in my career, I wound up being brought into other people's cases just to think about legal issues numerically and how to present probability. So I wound up litigating for 25 years. As part of that, I attended mediations. But I think some of us who are mediators, this is a Ryder, retired Greyhound here, racer. But, you know, litigation's great for lawyers only 20, 30 days out of the year. The rest of it we're spending in discovery disputes and doing other things. And for me, the real attraction of being a full-time neutral is that every day is potentially resolution day in a way that is transformative for the parties. And, you know, I truly believe that. I know some people sometimes might roll their eyes, but, you know, mediation is an opportunity, regardless of whether it's a court-ordered opportunity, regardless of whether the parties agree that this is a good time. And so I like to be able to try to facilitate folks to take advantage of those opportunities.
Right. Did you find your practice in insurance coverage, particularly coverage issues involving liability policies, helpful in terms of the fact that as an insurance coverage lawyer, I assume you were often asked to master or get command over some underlying liability scheme, the Fair Credit Reporting Act, whatever, antitrust, and then you get command over that issue, and 2 weeks later you've got a completely new one, and you become an expert in that. Was that your experience?
Yeah, I think a lot of times when people say they're an insurance coverage lawyer, people think that all they're really doing is reading insurance policies. And don't get me wrong, there's a lot of that in insurance coverage, but it's also assessing the risk of what may or may not happen in underlying litigation. And so the cases that I was doing a lot of were construction defects, environmental Superfund sites, mass torts, pharmaceuticals. And so I think even though it's a narrow niche in the law, it also exposes practitioners to wide array. The first coverage issue I ever had to deal with when I was a summer associate was how many occurrences were in claims against an archdiocese for pedophile priests. So there's definitely a lot of different exposures that you learn, when you're doing that type of work.
That's the Diocese of Winona case from the 8th Circuit.
Well, I think when the movie Spotlight came out, the only people who weren't all that surprised about it were coverage attorneys, because whichever jurisdiction you were in, unfortunately, there were a few of those cases hanging around.
Right. Now, you started your mediation practice while you were still a litigator, is that right?
Only very briefly. I am an advocate of I went cold turkey. There was a fork in my life, in the sense of my wife had a great opportunity. We were living in Chicago. I had a small boutique coverage firm with some partners in Chicago. My wife had an opportunity to take a job in Austin, Texas. And when we came down, I joke with my clients that I have implemented the world's worst business plan ever, which is practice 25 years in one jurisdiction, move somewhere, and then put up your own shingle in a jurisdiction where nobody knows who you are. Add COVID, which started 4 months later, and it made for a bumpy first couple of years. But I know there's people who both stay at firms and litigate and mediate. I joke that I'm not sure that I have the moral compass for that. When I was doing insurance coverage, I was fortunate enough to be entrusted to make recommendations on cases for amicus briefs, for test cases. And so I think I never could turn my mind off if I was mediating a case that was an important issue for one of my institutional clients. I don't know that I could be as neutral as I think ethically I needed to be. So for me, I just made a clean break, and I am a 100% neutral. I do arbitrate as well, but it's mediation and arbitration, and no litigation anymore.
Do you, I see this more often than I expect to. Do you still see a preference among a lot of lawyers or perhaps their clients for a mediator who's geographically local?
I do. I do. And
what do you think explains that?
Well, I think sometimes it does help if you have practiced in front of the court and the particular judge. As a mediator, it doesn't happen all the time for me, but particularly my Illinois cases, if I can say, look, I've been in front of Judge so-and-so, and I think while I respect your arguments, I don't think you're in the best jurisdiction to be articulating them, or something like that.
Yeah.
So I think that helps. And I think that even though we as lawyers, I had a national practice. So ironically, I'm licensed now in both Illinois and Texas, but I hadn't litigated in Texas, even though I've probably litigated in about 12 states. And as lawyers, I think if you're I know Rick and Lisa do aviation. You and I did a lot of insurance coverage. I think if you're familiar with the issues in one state, you can very quickly, especially Lisa's picking up issues in different, countries. I think we as lawyers think that we can, do that. But clients, I think sometimes prefer to have somebody in the same area code that they're litigating.
Right. I almost had no cases in Pennsylvania because the Third Circuit Court of Appeals gave judges enormous discretion to dismiss declaratory judgment actions. They finally reversed that 2 years ago, but I was going all around the country instead of practicing in my home state. Tell me about what kinds of cases you're seeing a fair number of in your inventory these days for mediation.
Well, my mediation practice is predominantly insurance coverage. I see subrogation claims among carriers that might have reserved their rights. They knew the underlying case should have settled. It does settle, but the carriers can't determine who should be paying what. I see a lot of here in Texas. When I moved to Texas and told folks that I was experienced in coverage, a lot of folks heard that meant I've done a lot of first party weather related events. And so those make up a fair amount, different hurricane cases, God forbid it got cold for a couple days. We call that Winter Storm Uri, a couple years ago. And so there were a lot of claims. I told all of my friends back in Chicago, they said, how bad was it? I said, well, they call it Winter Storm Uri here in Texas. In Chicago, we would have called it Tuesday. But when your infrastructure isn't equipped to deal with it, it led to a lot of claims. Frankly, I didn't have water for 2 weeks, and I've never been colder inside because my house was about 38 degrees inside when the power went out. But those lead to a lot of claims. And I've done a lot of other commercial cases. And, I joke that at the beginning of my practice, it was a little slower. One of the things that I did the first year, and I still do, are a lot of pro bono cases. So I got trained to do family law. I have done employment cases, any type of business dispute, breach of contract. But for the most part, I do think that people call me if a dispute, whether directly or indirectly, has an insurance component to it.
Right, good. So let's turn to your article about artificial intelligence and mediation. I have a very general question. It may not be possible to answer it comprehensively, but what in practical terms might the use of artificial intelligence in a mediation look like?
Well, as my article said, I guess I'm a confessed Luddite in that I'm not ahead of the curve on this one. And so my article suggested that, like Westlaw, and Shepard's, at some point we all, learned about a new tool and different folks were a little afraid to get into it. That's really where I'm at now. But I know that there are some of our colleagues who use it in a variety of ways. One thing that I've heard some people do is, I don't know about you all, but I joke with my wife about the difference between arbitration and mediation. In arbitration, my deadlines are generally respected. So a lot of times in mediation, we'll agree to get me something 4 days, 3 days before, and it turns out I get a submission 2 hours before the mediation, and it includes a 100-page expert report. And I have not done this, but I do know that there have been some mediators who just immediately ask ChatGPT for a summary of a 100-page expert. Now, as my article suggests, I'm a little bit concerned about some of the privilege and confidentiality concerns. But what my understanding is, and I've done this not with a report from a case that I've had, but just from, different articles, I've played around with giving, ChatGPT or a different service that type of report and asking it to summarize. And it's crazy how quickly it does it. Now, I think we've all heard about the ChatGPT lawyers out in New York and
Well, tell us about them now. Yeah, that's part of your article. So yeah, let's hear. Not everybody might have heard these stories, and they're worth retelling anyway.
Well, so these folks, and it's if people are interested, there was a hearing to show cause. I think is it the Mateo case? But anyhow, they were lawyers who asked ChatGPT about a particular legal issue, and they were pleasantly surprised that there were multiple cases that were directly on point that supported their position. So they put it in their brief, and opposing counsel wrote a response that noted that they were unable to locate like 3 or 4 of the cases in their brief, and they asked counsel to provide it. Now, at that point, the counsel probably should have realized that there might be something up. Unfortunately, they doubled down and asked ChatGPT again about whether that was still good law, and it actually even printed something out that they provided to the court. So at that point, when these are what people call hallucinations, that for some reason, and even the programmers and people who are very knowledgeable with these programs don't know exactly why. But these cases were bogus. And unfortunately, the second time that they backed that up, the lawyers wound up having a show cause hearing why they shouldn't be sanctioned, and they were sanctioned. It turned out that their subscription to Westlaw had run, so they hadn't been able to double check. But so it definitely is something scary. I know Judge Starr here in Texas, federal judge, and I think the Northern District of Texas, was one of the first of now many lawyers who have standing orders requiring parties, if they use AI, to affirm that they're going to double check things, which to me is actually, whether if I was back litigating and I was a partner, whether I might use a bad case because an associate didn't understand it, whether somebody missed I still have an ethical obligation to look at it. So I'm not sure that there needs to be a separate rule, but I think there needs to be an understanding in the bar that going to ChatGPT is not the same as going to the Federal Reporter.
Before people were reading cases online, it was extremely rare for somebody to cite to a dissenting opinion as if it were the majority opinion. But that is not that uncommon now, although Westlaw and Lexis have gone to great lengths to make it's hard to miss now that you're reading the dissenting part. part.
All right, now you're not mentioning that because I had a LinkedIn post today that was discussing a dissenting opinion, but I knew it was a dissenting opinion, Rich.
One part of the article I found really interesting was the potential for the computer to present a mediator's number in a case. A mediator's number is something that usually happens late in negotiations, where the mediator puts a number on, usually saying, this isn't necessarily what I think the case is worth, but this is what I think it should settle at. The parties in what's called a blind procedure will each say yes or no to the figure. If both sides don't say yes, neither side finds out what the other side said. The reason why it makes mediators nervous to do that themselves is if Steve's in a mediation against Lisa and Steve thinks that the case really should settle at 80,000 and my mediator's number is 30,000, Steve's not going to be excited about mediating with me as the mediator very much longer. But if you could foist that upon a third party or a program, that might be interesting. What are your thoughts?
Well, I think it's real interesting how you framed that. I think there's a lot of issues. I think some people believe, like I think you were implying, that the parties might either be more likely to accept or less aggravated with the mediator if they hear it comes from the computer, right? My concern about it is we as mediators, we touched on confidentiality concerns. The two touchstones of mediation are confidentiality and neutrality. And where I get concerned about the notion of we've hit an impasse, I can maybe type into ChatGPT the negotiation history and see whether it has an idea of what type of mediator's proposal or other suggestion can be made. My concern about that, putting aside that I think the parties would need to consent well beforehand that I might even suggest this, is, as we all know, whether it's Westlaw, Lexis, or ChatGPT, how we ask the question influences the answer. And my concern is, if I were a litigator, I'd want to know how the mediator framed something. And I frankly want to maybe negotiate a little bit as to how it should be worded. And as a mediator, while I respect that that might be an impulse for parties, I just think it's very difficult for me to maintain the appearance of neutrality with the parties if now they're thinking that the way I asked the question shows I was biased towards the other side. So if I were to go down that road and make the plunge, I think up front, not only am I asking consent for it, I'm going to say, if we use ChatGPT, you're not learning how anything was framed towards it. You're only getting the impact, and you're trusting me as the mediator to control that environment. Because I think if it was an open forum, it would be very difficult. You're muted, Rich.
Yeah, I have a dog here too. He was growling. Can you see AI completely replacing mediators in terms of the mediator's skill currently in getting parties to move off of a number and getting past supposed impasses?
I mean, I think in the bigger picture, there's a lot of industries, lawyers, and salespeople who are all worried about whether the computers are going to take over the world and all of our jobs. I think the realistic answer is there probably will be some type of cases in some courts in which it will be used much more than it is now. My understanding, I'm a AAA arbitrator, in the last panel conference I went to, I think they noted that, like, in Saudi Arabia, there's a form of required AI mediation, right, as you're filing cases. So I think there's going to be dabbling in it. But I also think that as long as people are involved, that they're still judges, that they're still lawyers, then I think there's going to be some folks who are still going to prefer people. But I think it would be very naive to think that it's not maybe small claims courts, instead of going in front of, that judge right away, you go to a kiosk and the computer tells you what its value of the case is. And if the parties agree that that's a reasonable settlement, then poof, the case goes away. I think that likely is going to happen. I don't think 100% though.
Anything you'd like to add that I didn't touch on before we go over to Rick?
No, I don't want to take on Rick's time. Like I said, Rich, at some point, I think you deserve the opportunity to let us know a little bit about yourself, but I appreciate the
I want to make sure Rick gets his time in, and then I'll squeeze it in. I remember once I was at the very end of one of these things, and the moderator told me I had 4 minutes, and I said, so in conclusion, so we've got, Rick, we've got about 14 minutes for you, so that should be.
Rich, I yield 1 minute to you.
Okay, well, all right, I will. I am Rich Mason. I'm the newsletter editor here. I was a former chair of this committee and one other within TIPS, longtime TIPS member going back 25, 30 years. I also was a commercial litigator, primarily in insurance coverage. Went out on my own 3 years ago, and I'm enjoying it immensely and finding it very satisfying. There's nothing more satisfying than getting parties to settle in a fair way. So there we go. Now we can move on to Rick. Rick is a mediator, and you're also still a litigator. Is that correct?
Yeah, I try to balance that. As Steve pointed out, not everybody does it, but I continue to practice law and mediate as well.
And like Lisa, your non-mediation practice focuses at least in part on aviation. Is that right?
Yeah, Lisa and I have known each other for almost forever. Yeah, I do mostly airline defense, but also some product liability and a mixed bag of other aviation cases. And basically, that's been what I've been doing since law school. Out of law school in 1989, practicing starting in 90.
And what kinds of cases are brought against airlines?
Well, they're not all that sexy, I can assure you. And that's one of the first things I have to disabuse people about when they about aviation and airline in general. The bad news is that there's not a lot of like really major crash cases in terms of like my ongoing caseload. They do happen. The good news is that they come across such a broad spectrum that people thinking aviation law is highly specialized would be surprised to see that in any given day, I might have a products liability case, a premises liability case, an international treaty case under the Montreal Convention. And it's also not uncommon to be dealing with insurance coverage and contractual indemnity. And at any given time, now those are among the areas that are encompassed in aviation litigation, a common denominator probably being, as you and Steve would understand, and Lisa, an insurance policy that determines it's an aviation case.
Right. I know there's separate policies for the hull of the aircraft and then another one for the liability, right?
And then there's a whole, and that's just in the product side, or I'm sorry, in the first party side, but in the liability side for an airline, that's a different policy. So
there were a series of crashes in the late 1990s that virtually bankrupted a few insurance companies. How did you come to get a place on the mediation panel for the Eastern District of New York Federal Court?
Southern District, and I was lucky. I happened to be looking into mediation training, and I just did a Google search at the right time, and saw that the Southern District of New York was doing training new mediators from scratch. And I made the cut. I got in the program. I was trained by the court itself. and trained into areas of law that I otherwise would not be practicing. So they educated me on things like 1983 civil action, employment law, cases that are on the mandatory mediation track at the Southern District, and it was extraordinary. And Rebecca Price, who has been with the program as the mediation coordinator since then, continues to be a tremendous resource, and they continue to have an outstanding mediation program. And I just happened to get lucky to look at the right time, because literally, I think a dozen years passed from that course to the next one being offered. So I was almost in the last graduating class for the Southern District.
Do you see any differences in how the parties conduct themselves in a court-annexed mediation compared to one that the parties have done entirely on their own initiative?
Well, absolutely, because when the parties come to you having retained you as a private mediator, they have made a decision to mediate. When it comes to you from the court has made that decision for them. So they may not feel the mediation is ripe. They may not be as invested in the process. However, the success rate is still quite high, like 60 to 75%, even though they're mandated. And I believe that the mediator's approach can invest them in the process more. And for me, that's by being very proactive in getting submissions early and getting pre-mediation calls going and building some momentum and requiring they do some work. You know, when you do some work, that invests you in the process. And it's my view that, you know, we as mediators, we have our own guidelines. And if the parties don't make reasonable efforts to comply with the deadlines that we set, that we agree to, I put over the mediation and make it clear that look, we're not going to do this unless you do this, you have your submissions in and follow other protocols. So by insisting on a certain level of work, I think, maybe hope is the better word, that the court-annexed mediations take on more of the aspect of the private because of the investment in the process.
Have you ever, without giving any details, of course, have you ever had to report to the court your view that one of the parties didn't participate adequately?
No, that I would say there were some that were tempting, but no, I've never had to take that step, thank goodness. And it's really it's a very light, I was going to say high standard, maybe a low standard is the better term. But I mean, for example, look, the parties are going to occasionally have a no pay position.
Yeah.
And there's nothing unethical or improper about having a no pay position, particularly when they're being forced to mediate. Now, if somebody comes to you in a private mediation, a two-party private mediation where they're coming in with a no pay position, you wonder why they're bothering. But a no pay position is a legitimate position. It's certainly not bad faith. So no, thank goodness, no.
So your article talks about mediation having gone from a relative rarity in 1990 to becoming virtually inevitable today. What are some of the causes that have led to this?
I think it's cost driven. And I think that one of the things that contributes greatly to the cost is the explosion in the cost of electronic discovery and even a moderate case. So that the parties looking at the road ahead of them can really see an opportunity to save money. But costs have gone up across the board, and it's just been a cultural shift too. And I think, as I mentioned in the article, the phase of the litigation in which parties mediate is coming, in my experience, becoming earlier and earlier. Part of that might be that a lot of the court-annexed mediations insist on a relatively early mediation, and have success rates. So parties are beginning to understand that that they can have a successful mediation sooner. And I also think that I know that when I'm litigating a case, I look at what I call to be a critical mass of discovery that is well short of what I would need to be trial ready, but gives me enough of a understanding of the case and the facts, and as necessary, of course, the law, to proceed with a mediation effectively and sufficiently informed. And I think a lot of lawyers are looking at getting the case mediation ready as a new threshold and an earlier threshold in the lifetime of a litigation.
Have you ever been involved with a case where the parties agreed to do mini depositions, 2-hour quick depositions, and then reserve the right to do more expansive ones if the mediation were to fail?
Not specifically that, Rich, but very often, and this is one of the benefits of the pre-mediation caucuses, is the parties feel there are 1 or 2 really critical items on the discovery menu that they want to get done before they mediate. And I'll give you an example, an employment case, and they haven't exchanged the HR file yet. And that HR file could have a lot of bearing on whether there is a justifiable for cause reason for the termination. And it also happens in the context of we haven't mediated to a successful conclusion at the mediation itself. So we engage the parties and look, what do you need? And often it just becomes obvious in the course of the mediation that there are some things they need to get done. But very often it's like, let's just take the deposition and get back, not do a mini. But other times it's documentation that you can have a pretty finite list of something to exchange, get it done and get back either in a mediation or just working the phones.
Right, good. And you're one of the central concepts of your article is how mediation is like a day in court. What are the similarities and the differences?
Of course, the biggest difference is self-determination. The mediator can't make anybody do anything. So, and the mediator has to stress that. But nonetheless, the mediator is somebody who either the court has chosen or their parties have agreed can help them resolve. So that, I think, instills a decent level of credibility to the mediator. And the mediator, and this is one of the reasons, and one of the controversial topics is the opening statement, the joint session. And in most cases, we proceed with that opening to provide a more formal forum, particularly for the plaintiff, to go through the process of feeling that their case is heard. And as my old boss Bob Kraft would say, they're about as spontaneous as a coronation, if we do it right, which is to try to really, and particularly with the defense side, understand that the plaintiff needs to make some points, and that the defense should not escalate, but offer professional responses, always followed with the olive branch of open mind, here to negotiate. We can agree to disagree and move on. And that experience can really help the mediation progress positively.
We have a question from the audience that just came in. What is your strategy for getting a defendant to offer money within their authority when the defendant perceives that the plaintiff is not realistic in its demands?
It is to offer, generally this sounds very simplistic, but offer something. And I'll give you like the typical example is where there's an enormous demand, and the defendant is taking the position, we're not even going to negotiate until they come down within the realm of reason. And then I have to explain to the defendant, look, nobody's going to bid against themselves. Did you have a reasonable opening offer in mind, just irrespective of what the demand was? What was that? Does that opening offer still give you a lot of room to negotiate? Yes. So what is the downside of getting a reasonable opening offer on the table and at least going one more step? And then evaluate, because they, typically, if they're going to leave the mediation having only broadcast 1/3 to 1/2 of their authority, they're not leaving the mediation having spent their last dime, but maybe we've made some negotiation. So I typically encourage them to make an offer based upon a reasonable offer without giving getting too concerned about how high the demand. And of course, with a little luck, and I know we're running out of time here, with the advantage of pre-mediation caucuses and ex parte statements, I very often have more optimism than either side, because I've gotten a much better feel for what their positions are. And I will say something, look, I know this is discouraging. I can't share with you confidential information, but I assure you my optimism is not unfounded. So let's make an offer. And they read between the lines.
Right. It's very good. Yeah. Sometimes they can make an offer they know the other side's not going to take anyway, so they lose nothing and they might learn something. Right?
And I prepare both sides on the opening offer. This is going to be a number that you're not going to take, and you might even be insulted by it.
Yeah.
Be ready, and we'll move on.
All right, we are just over the hour. There are no further questions from the audience. If you do have some, you can email me at rich@MasonADR.com, and I can relay them to the authors. But with that, unless anybody has anything else they'd like to add, then this program is concluded.
Just thanks to you, Rich, in particular, and to the other panelists. It is the newsletter, as Steve and I have both come through that job with TIPS and this committee, is critical. It's an important job. It's really the critical work product of the committee, Rich. So, thank you for all the work you do and continue to do, and for a great job moderating today.
Thanks, that's nice to hear.
Thank you very much.
Have a good day, everybody.
Thank you.
All right, thank you.